I want to thank Henry and Naomi for inviting me to participate in this workshop. I think they know that their research and their support has been very important as I work to place China within what is often an alien history of Western business development for us. I also want to say that reading the papers for this workshop, it's not difficult to imagine that I have data envy. So I hope that the more discursive presentation that I've been able to put together will be useful and interesting for people. China's not often discussed in the histories of the corporation, and I think this is in part because it's not seen as contributing to the debates that shape the development of corporation law in the West, which of course becomes a kind of dueling global standard, as we saw in the last paper. But it's also because of the uneven progress made in China towards acceptance and utilization of legal transplants that were meant to fill the gap between Western corporate law and Chinese business practice. There's certainly no question that early Chinese transplants fell short of adequately duplicating either Anglo-American or continental statutes on the corporation. And if you look at the actual books that have been written about particular Chinese quote unquote corporations, you see that even when businesses chose to embrace the corporate form, they often continued to incorporate modes of organization and ideas about risk and responsibility that were drawn from earlier experience. So for this reason, I decided to approach the history of the corporation in China from a different angle, looking first at the context within which the idea of the corporation and its significance as a legal innovation first came into contact with these existing Chinese mechanisms for raising joint stock, and then focusing on one of the major conceptual differences between business law in the West and business custom in the pre-statute phase of joint stock business organization in China, what I've called apportioned liability. And I do want to emphasize that term very, very exactly tracks the Chinese term that's being used. The first item of context, I think, has to be recognition of China's own very robust history of jointly invested business. Like many of the precursors of the Western corporation, I think it can be partly narrated as an aspect of the history of kinship and native place networks. Its most notable exemplars also, as in the West, made their fortunes in long distance trade, and in the service of that trade, developing new modes of payments, excuse me, new quasi-banking institutions, new ways of investing and allocating benefits and obligations. And you also have certain similarities in the emergence of foundations that are not particularly oriented towards business. In the West, we see the model of the Church Foundation as forming an important template for corporate asset holding. In China, wealth holders developed the institution of the lineage trust, which I've talked about elsewhere, in which members of a surname group would shelter assets from what were in China statutory requirements of equal inheritance among sons. And again, they originate as for charitable purposes, but over time they begin to be used to structure shareholding entities that allow long-term capital accumulation and business development. At the same time, recent research covering disparate parts of the Chinese empire has also shown that Qing subjects were developing mechanisms for investing with strangers, buying and selling shares with strangers, managing multiple disagreements that inevitably emerge from the business environment, all without any kind of commercial or company law on the books. At the same time, there are some really critical contextual differences between the history of the Chinese jointly invested business and those that form the basis for modern Western corporations, which is the interest that most of you have. And I think it's worth emphasizing, excuse me, that one of those is the role of the state. The Chinese state in the imperial period had a highly sophisticated legal system, excuse me, but it took almost no interest in regulating commerce. In fact, some of us have talked about the fact that there's very little taxation and very little regulation of business as kind of being the model of laissez-faire that Westerners would almost hesitate to dream of. At the same time, China's centrally appointed bureaucracy accommodated a largely free trade region across the entire continental space that the Qing Empire occupied. This certainly encouraged a variety of local practices, but it also encouraged the circulation of knowledge. And in looking at the numerous surveys of local customs, some of which I mentioned in the paper, you really get a sense that at least by the 19th century, we're beginning to see a convergence under the influence of a growing long distance trade, and also the movement of officials across jurisdictions who are then adjudicating these various local customs under a growing understanding of rules of commerce. The largely absent hand of the state in regulating business and commerce also has to be understood in conjunction with China's long history of contractual ordering of property and exchange relations. And this strong contract culture, I've argued elsewhere, was supported by the adjudicatory institutions of magistrates, courts, lineage, and village mediation, self-governing mechanisms of guilds, and so on. And all of this plays a role in our understanding of what's going on in this paper. Finally, I would say that Chinese familiarity with shareholding as a method for the creation of public goods and charitable foundations, as well as for investing in land, small business, and other undertakings, was very widespread when Western traders began to make their presence in China. Which really begins in 1600, but really can be seen as having the concentration of influence that we would be interested in at the beginning of the 19th century. And during this period, Chinese interest in Western modes of business organization grow, as did broader recognition of indigenous shareholding opportunities and practices among Chinese who are increasingly exposed to the market. Chinese business people, especially those in the eastern coastal communities that were most influenced by treaty ports, are also increasingly identifying their own longstanding practices of investing in business entities through the purchase of shares with a new vocabulary of the company, which is coming from the West. So one of the things I didn't talk about in this paper is the extent to which you see, even before the introduction of a company law, people beginning to advertise shares, write up articles of association, which incorporate some of the characteristics that they see in Western company law, and then selling shares on a public market with no regulation by the state. So it's not surprising that once the state begins to abandon its traditional neglect of the business sector, Chinese merchants understand new business legislation through their own lens, and many are resisting ceding practices that had served them very well to a new reformist state. Now, Chinese scholars, Westerners and Chinese, tend to characterize China's encounter with the corporation as a failure. And I think they've often lost sight of the fact that the 19th century was an important formative period for the company law in the West, as well as for China. Western practice offered China many alternatives, and the logics inherent in these alternatives, while meaningful in a Western context, were often not fully understood or did not fully make sense or seem relevant to Chinese business actors. At the same time, Western and Japanese interlocutors in 19th century China remained deeply curious about how Chinese business functioned, as corporation law, still evolving, met Chinese practices that address questions that face business and legal communities in their home countries as well. And indeed, if you look at the interactions among business people in Asia, Westerners who organized their firms as unlimited partnerships dominated. Chinese who purchased shares in Western joint stock companies were growing. Colonial Hong Kong authorities, we see, were convinced that they needed to establish a separate business code for colonial business subjects, one that they thought was quite respectable. So we're reminded that for the first few decades after the Opium War, there remains a kind of soft ideology with regard to how business ought to be structured. But this ideology really does harden over time. And indeed, in the chapter or the section of the book in which this particular paper is going to fit, it's very interesting to know that Western attitudes towards Chinese practices kind of serve as a bookend for the section. One end is the quaint and curious forum on Chinese partnership practice that was sponsored by the Royal Society in 1887 and that I discuss in this paper. At the other end is a totally non-inquisitive position on the part of plaintiffs in a representative lawsuit filed at the Shanghai Mixed Court by British creditors of a Chinese firm in 1926. In this case, Chinese claims that in local practice, shareholder responsibility for excess partnership debt was apportioned by shares is met by the British by the British claim that joint and several liability, of course, is the universal practice among civilized people. In the end, then, adoption of strict Western standards of corporation law and partnership law, I would argue, inevitably became a political and not necessarily an economic decision. While China was never a colony of any Western power, the Chinese quest to recover its national sovereignty, which was, of course, exemplified by the struggle to achieve the abrogation of extraterritoriality, which lasted in China for over 100 years, longer than any other place, from 1842 to 1943, coupled with what was a Western discourse of Chinese legal insufficiency, a term that was used by a former student of mine, Li Chen, and dated from the very early period of Sino-British trade, could not help but influence the way in which Chinese people understood their own law, and particularly political leaders who were trying to place China within a global framework. Interestingly enough, that term legal insufficiency starts to manifest itself in the 17th century, really because of differences in what British people saw as Chinese criminal justice, which they were constantly getting in trouble for accidentally killing Chinese people when they were doing trade in China. But as British investment in China, as Chinese investment in British joint stock companies began to raise conflicting notions of shareholder rights, as British traders themselves found themselves liable for the debts that were incurred by their Chinese employees, so-called compradors, demands for Chinese adoption of corporate law that resembled something that they understood would begin to compel Chinese economic actors to follow British practices. At the same time, we're going to see in the late 19th century, Chinese intellectuals and a new class of what we might call business thought leaders beginning to see the corporation as the key to China's success in what was increasingly called commercial war. And therefore, I don't think it should be surprising that China sought to recover legal sovereignty. And one of the first things that it does is to enact a company law. First in 1904, then revised and greatly expanded in 1914. We don't have many figures on how many firms actually fashioned themselves as corporations. I'm going to leave that out. Somebody can ask me, and I can speculate how we might think about that, as well as some of the reasons that people present for it. But what I will say is that partnership remained the important organizational form. And of course, we know that was the case not only in China. But as I suggest in the paper, partnership and the customs upon which Chinese partnership was built suggest an equally important reason for its persistence outside of, political issues. Do the Chinese people trust their government, and so on and so forth. Chinese custom allowed partnerships to accomplish many of the benefits of incorporation. Chinese partnerships face, I'm sorry, when I talk, I start to cough too. Chinese partnerships face no legal impediments to longevity, to transferability of shares. They were able to act as a single entity in court. And of course, to this, we can add the custom of apportioned liability, which I would argue served as a kind of middle way between unlimited liability and the limited liability that some have deemed to be the most important benefit of incorporation. And in China's late 19th and early 20th century, when capital markets were still in a formative stage, this custom was seen by Chinese as encouraging both investment and lending through the sharing of risk, not only among shareholders, but between shareholders and creditors as well, both of whom would then, I think, in economic terms, be understood as building these customs into their transactional calculus. This was a way of creating trust in a Chinese context in which banking was still very weak. Purchase of shares was tentatively moving beyond the context of face-to-face relations. And most businesses actually relied largely on equity investment and not on credit, except for materials and supplies. I have a few more things I want to say, and I hope I can continue to say them. So as I began following the traces of this process of legal transplantation in early 20th century China, efforts to refashion this legal system and bring what really had resided in the private realm into the realm of the statutory, the debates over apportioned liability actually outnumbered by magnitudes debates over the way in which the corporation was constructed. So I felt it became a really useful window into the larger problem of legal transplantation in the Chinese legal space in general. I think one of the other things that this paper allowed me to do was to think about the way in which the introduction of black letter law impacted ideas about the role of custom, the role of the state in regulating business. It allowed us to look at the workings of a new system of courts and the particular, if unsettled, role that was played by a new Supreme Court. It pointed to a new kind of activism on the part of business actors who are now seeing themselves as participants in the project of republicanism, and so on. And indeed,
Maddie,
I'll stop.
Yeah, you can. No, you don't. You can say a few wrap-up sentences.
I will say, just to kind of give you a preview of the future, what actually happens is that ultimately the hegemony of Western standards, and not necessarily the logic of the Chinese marketplace, is going to decide what happens in China when the Kuomintang takes over and implements its 1930 Kuomintang civil law. And then, of course, you have a law of partnership, which changes the problem that these people have to face. It's no longer ambiguous lack of law that they have to deal with, but trying to push for a new partnership law that acknowledges their local practice. So I'll stop there.
Thank you so much. We have a queue forming already. Amanda's first, then Henry, and then Will, and then I'm sure we'll have other people joining our queue.
Okay.
Okay, so I'll just say thank you so much for this paper. I just loved reading it, and thanks for your presentation, which actually answered most of my question, but I'll tell you what's left over. So
Okay.
I was going to ask about, how we should think about the trade-offs of apportioned liability. And, I was thinking, this is a system that privileges smaller partners, but maybe at the expense of creditors. And so, as you said, it helps partnerships have some of the characteristics that we might associate normally with corporations, and also it produces a structure where there's a lot more equity investment rather than credit. So that makes sense to me. But I'm wondering, and this betrays somewhat my narrow focus as an economist, maybe, but are there any disadvantages left over of this system? Would there have been any kind of partnerships that would have been disadvantaged by apportioned liability, or anything you can observe in the shape of how firms are founded that would suggest that something is missing by having this system or not? Are these questions that even make sense or that can even be studied? So thank you so much.
Yeah, no, it's really interesting because, you, first of all, when I said I have data envy, I mean, it would have been so wonderful to have, sort of the opportunity to see who opted for corporate law, what kinds of firms opted for this kind of Chinese hybrid, if you will. And then what happens later when you begin to have a black letter law that says that partnerships have to have joint and several liability. The only thing that we don't have that. I mean, and actually one of the frustrations of this whole project is that there's not even a lot of case law that one can dredge up from the Chinese archives, something that I've been trying to do for some time. But one of the things, so you sort of have to depend on what people themselves are saying. And I think the people who don't like this system are British business people who largely in this context are not, co-investors or they're people they're traders who are bringing, Western goods to contribute to, the manufacturing process in China. So for example, the 1926 case I talked about, which it sounds like very arcane, but it became such a big deal that actually I ran across it very early in my research and didn't realize its significance till I went back to it later. It was splashed all over the British press in China, as well as daily records of what was going on in the mixed court, both in Chinese and also in English, was about a company that decided that it was going to produce Western style umbrellas in China, but it was so it would use Chinese silk and other materials, but it was importing the metal components from British traders. And they actually originally incorporated, but because of glitches in the Chinese inefficiencies, you might say, in the Chinese bureaucratic process at the time, they ended up not fully completing the incorporation process. They went bankrupt, and so they were considered by the courts to be to be a partnership. And then most of the small investors disappeared and left the biggest investors holding the bag, and it was about £20,000. So that was a big amount of money. And they, so I forget where I was going with this, but so the British were absolutely insistent that they had to, immediately make up for the derelict co-investors, right? So whereas the Chinese community all come to their aid and say, no, this is, an example of why we have to kind of find a middle way in order to make sure that viable businesses don't fail. This one happened to be a bankruptcy case, but in many cases you would find, these kinds of pressures coming up in a case where a firm could have gone forward had they been able to deal with this immediate problem. So I would say that from the Chinese point of view, it does actually harken back to what I see as a commitment, not a commitment to a more public goods oriented notion of property rights, in which individual property rights are not sacrosanct, that you always have to look at the larger picture. And in fact, in my own experience, looking at different kinds of cases, even disputes over inheritance, the judges will often say, well, this son should have gotten this and this son should have gotten that. But if you do it that way, this son is not going to be able to make a start in life. And so we're going to find a middle ground. So that's the best that I can say to answer that question.
Thank you. Henry.
Okay, well, this is a terrific paper. The other paper has been looking at corporations, and of course, the alternative to forming a business corporation in virtually all societies is either not to form anything at all, or more likely to form a partnership. And it's important to remember that the partnership was the instrument through which England traveled through the Industrial Revolution. All those firms out there were partnerships. Carnegie Steel was a partnership when it was formed, and until it became the largest steel maker in the world, I believe. So partnerships are important, and they ran the world for most of history, and they're still out there. Though surprisingly uncommon in the United States today. I don't think anybody intentionally forms a partnership today in the United States. Anyway, this is a critical factor. This competition, as it were, between corporations and partnerships for the control of enterprise or the formation of enterprise, and it's important to know what's going on. Let me say in this regard that I like the fact that that we have a book coming out here, a book that tells stories, that has anecdotes, the umbrella company and so forth. We get a sense of who is involved, who the investors were, what their stake was, what their disputes were, what they were manufacturing, what their markets looked like. There's of course the ancient adage that a good anecdote is worth a dozen instrumental variables, and I think we see it here. I think all the papers that we've heard today would be enriched if we could get some anecdotal data, just to get a picture of one or two entities that were formed under these laws. The norms of scholarship, of course, force you to get it all out in 25 pages and plus graphs and charts and so forth. And this pushes us to treating everything as a homogeneous mass and picking a few characterizations of the data to look for correlations. I think to understand organizations, we're going to have more work like Madeleine's, which tells the stories as well as gives the data.
I'm waiting for the but.
So let me say a word more substantively about what Maddie has shown here. The situation looks like a mess. It isn't clear what partnership law means, what it means in dissolution. It isn't clear whether what the claims are, the legitimate claims that a creditor of the organization has against the partnership. Is it joint and several, or is it not? Or is it just joint and pro rata? That makes a big difference. If it's pro rata, can you sue? Can the creditor sue anybody? And they've got to cross sue to get the proportional contribution of the other partners, or must the creditor go and sue each individual separately for what they're liable for? These things, I think it's important to understand, were not so well settled in American and British law. They were vague and, to my knowledge, changing into the first part of the 20th century. America adopts, I believe, in 1906, a uniform partnership law. that finally clarifies a little bit some of the mess that the courts had made out of it. So we shouldn't think that things were too well organized in the alternative. And having said that, the messy situation that Madeleine describes, where it's not, where sometimes you get joint and several liability and sometimes you don't, arguably fits well in the context there. I think fair justice and efficiency may have been served by this set of uncertain compromises and lack of commitment to precedent. And the mixed court, like the similar court perhaps in Egypt that was described to us, may have done fair justice. We had foreign creditors and we had domestic operators in China, it looks like, and Chinese investors. And when the thing falls apart, who's liable to whom for how much? Well, it depends, and it ought to depend on a lot of things. And we see here in China, it does depend on a lot of things. And you can't just say you get joint and several liability. You, in some contexts you do, in some contexts you don't. And it depends a little bit on who the parties are. So it isn't obvious to me that China didn't solve the problem pretty well. Maybe the mixed courts did a decent job of discovering and allocating funds in dissolution according to the expectations of the various parties. Sometimes the Chinese parties may not have understood what they were getting into with joint and several liability, and in some cases, foreigners may have been served, of course, by very clear property rights in the firm in case of dissolution. And no two situations are likely to be the same, and maybe predictability is an overrated virtue in the law, and maybe some little fairness out there where you try to adjust outcomes to people's knowledge and expectations and commitments makes sense. And you want to do a deep dish examination of what those expectations are and pass out returns accordingly. So I'm not sure we've got a picture of a legal system out of control. We may have a picture of a very sophisticated legal system that has partitioned claims and assets in subtle ways. So here's two cheers for the mixed court.
Shall I respond? Thank you. There's no question there, Henry, but you did raise a huge number of really important issues, and I'd just like to respond to a couple of them. First of all, the mixed courts, of course, as people know, only dealt with cases between a foreigner and a native person, right? So foreigners had an advantage in pressing their own understanding of what the legal framework was, because they would be tried in these courts. Now, those courts had two adjudicators, two judges. One would be Chinese, one would be foreign. I'm not sure how they probably worked similarly in Egypt. And they had to come up with a unanimous decision. So that often left some ambiguity as well. But it's a very useful, and those cases do survive. So we have the examples of those to kind of see how the working out of those problems are with Westerners. What I found really interesting about what you were saying, I do agree. I don't think that it's chaos. And I think in some ways it becomes chaos when these alternative foreign ideas about how these things ought to be resolved are injected into what had initially been a process of, especially in bankruptcy, often a process in which you had tribunals in which all of the creditors would participate, and there were clear notions of who would get priority, and shareholders did indeed have the last priority in these, but would be judged, their responsibilities would be judged according to these apportioned laws. What happens in the next part of the book is that, as I said, the Guomindang actually finally issues a civil code which ends dispute over what a partnership is, and they adopt the German regulatory framework, in which case you then immediately see people moving from an argument that contract should trump everything to we need a new law that actually codifies our understanding of apportioned liability. So it's a very interesting way of examining the progress of legal development in a context that is not the one that we're accustomed to in the West. So I really am so grateful for your comments.
So we have 3 people on the queue. First Will, then Jihan, and then Mariana. Will?
Yeah, hi, Maddie. I just, while you were talking, I wasn't quite sure how much this related to the Chinese experiment with publicly traded corporations, or much more generally to the form of organizations that sort of never saw the light of the trading floor. But the thing that, struck me is the unusual nature of the Guandu Shanban publicly managed public oversight of a private company that we really didn't see explicitly in any other nation's corporate organization. And I wonder if you had been thinking about that for your project, and it can have positive and negative implications of essentially having a government official on your board of your corporation as representing the interests, supposedly representing the interests of the public in the operations of the corporation.
Let me say that the Guandu Shanban, or the translation that's usually used in English is, oh God, I'm getting the constructions. publicly invested, officially supervised company, is something that exists, as I know you know very well, because you've written about it in a number of places, but it exists as a kind of moment in time. I think it's somewhat misunderstood. It comes at a moment in Chinese history in the 1860s and 70s, and really starts to disappear in the 1880s, when the Chinese, when China has just come out of basically a horrific civil war. They've also had to begin to confront the impact of the unequal treaties, and they are beginning to focus on industrial development, mining development, and so on. And one of the misunderstandings is that some people read this to mean that China did not have jointly invested companies before this, and that is not true. Where the Guandu Shanban company kind of fits in is perhaps in a narrative of big push, efforts at a big push, but a big push not from the central government, but from individual provincial officials who've gained a great deal of power, having been the leading lights and accruers of both political and monetary assets during the fighting of this civil war. And most people think it doesn't work very well, although there are a few of them, like the China Merchant Steam Navigation, which work quite well. They were started in part because people thought that, regular Chinese people would not want to invest. Indeed, they did want to invest. In fact, they invested so much, and they were so caught up in, especially in the region around Shanghai, in the speculative stock fever that emerges out of this period that China experiences its first financial crisis, big stock bubble in 1883. So it's kind of a blip. The government does put money into these things. The government also, I mean, Albert Feuerwerker, for example, may he rest in peace, argued that this, that this injected all kinds of inefficiencies and nepotism and so on. One of the things that I find really interesting, and I'll just mention it, is that these Guangdu Shanban industries in some ways resemble kind of official holding companies. Because one of the things that they did was that once they had invested in something that was successful, they used the resources, the assets that emerged out of the profits out of one, and were able to invest them in another. So they resemble in some ways what the Meiji government was doing in Japan. And the Zaibatsu did as a private kind of organizational framework in the aftermath of when the Meiji sells off. I think it's not, but ultimately the government withdraws and turns the process over to private investors. So I'm not sure I'm not going to do a huge investigation of those Guangdu Shanban, partly because within the China field, they sort of feel like they've gotten all the air in the room. but I certainly think you're right in that in the ultimate project, I do have to mention them.
Yeah, that's a very nice perspective. That the context is something I hadn't really understood entirely before, but I like the idea that they're just this transitional blip that depended upon those resources, as you describe, that emerged from the Civil War. So, thank you.
There are other things going on at the same time. You've worked with Elizabeth Cole, so I mean, she looks at another sort of model of, a member of the elite, a member of the gentry, who then decides that he's going to develop cotton textile manufacturing in his region of the country. And he doesn't try for Guangdu Shanban, but he certainly gets the initial kind of push to be able to begin his company by getting a grant of machinery from one of these important Guangdu Shanban forming officials, and then goes off and forms a private corporation. So it does play an important role, but one that disappears. But of course, everybody likes to talk about it as the model for state-run enterprise in China.
Okay, we have only about 5 minutes left, and we have 2 more people on the queue. So first, Jihan.
Thanks for that. So I found a lot of similarities between this Chinese experience and for example, the Ottoman experience, especially, both countries were not fully colonized, but there was this element of extraterritoriality that sort of extended. And I'm wondering if you see a similar sort of extension of this sort of incursion of European law into a space where indigenous people could also take advantage of these laws even before codification. And do you think that affected the transplantation process in a way? Like maybe the Chinese government said, well, we don't want, this is an affront to our sovereignty. We need to, we need to get a hold of this. And maybe that affected somehow, how they viewed these indigenous institutions that preceded before.
It's really, that's such a great question. And it certainly is something that I will be talking about. And I kind of hint at it, but I don't really develop it. So let me say that you see change over time, obviously, but in the period before there's codified law, I mentioned the existence, the ways in which Chinese people begin to kind of associate what they're doing with this notion of the company, right? There was never the word company in Chinese parlance, but they see what they're doing in forming these business entities as being like a company. And some of them even begin to use some of the accoutrements of being a company. As I said, they will have articles of association in which they lay out the kind of following a model of what they see in British companies, which some of them are investing in. of what, shareholder rights are, boards of directors. We meet once a year, we will settle accounts once a year, these kinds of things. And they publish them in newspapers and to attract investors. The other sort of side of it is government is struggling with how to, they're not just thinking about business, but they are struggling with how to deal with a population, and particularly an elite population, who have certain very deeply embedded ideas about human relationships. They have a property system in which property actually belongs to the household and not to the individual, and in which there are certain kinds of rules of the game with inheritance and so on. So when they begin to try and formulate a new civil law that will make them part of the civilized world, and I think Egypt probably had the same thing, this urge on the part of peripheral countries to become part of the world historical project, there are a lot of conflicts and people are not happy. That, for example, girls should inherit. No, only sons should inherit. Inheritance should be this way or not. So it really holds up the implementation of a civil law, which in turn it makes it hard for them to get this clarity in the partnership law. And then, as I said, once that is decided in the promulgation of a new civil law, then the rules of the game change and people start putting pressure on the legislative process to incorporate their ideas into black letter law, as opposed to arguing that custom and contractual agreements are what governs the relationships within business. So it's fascinating to me the way this works, but it takes place over about 100 years. I mean, it's not an easy process.
So we will have the last question now, which is from Mariana Parkin.
Hi, thank you. What a terrific panel this morning with so many lessons from comparative corporate governance and the history of corporate governance beyond the wealthy West. I was very intrigued about the story told in this paper. I also had a reaction perhaps similar to Henry's, in that my reading was that perhaps original Chinese law was perhaps quite advanced, in that it might not be completely clear that joint and several liability might be more efficient necessarily than apportioned liability. Considering what is in the paper and also what was in the presentation, I was also very intrigued by the fact that apparently these partnerships had many of the so-called corporate attributes, such as transferability and representation in court. So I was really wondering to what extent one might be able to say that those partnerships actually embodied some of the developed corporate law attributes. So because of course, partnerships and corporations are just names. So I was wondering, given the basic functional elements, whether there was really some aspects in which those partnerships were perhaps ahead of the game in the evolution of business forms, being the adoption of joint several liability by statute, then actually a step back.
So I don't have very much time, but let me answer it in several ways. First of all, I'm not arguing that you don't need corporate law, that corporate law has no function. What I am saying is, how did these people understand their own business environment and what they needed out of corporate law? And I think as you begin to get larger companies, as you begin to get a much broader investor pool, I mean, some of these things are going to become extremely problematic. But they did not, when you think about longevity, partnership longevity, I remember when I first read Naomi's article about partnership, and I thought, well, Yeah, the law says that a partnership has to dissolve after the partners die. Well, we don't say that, so you don't have to worry about that. So you just pass on your shares to your wife or your children, or you sell them to your uncle, or you sell them to some stranger. Unless there's something in the agreement between the partners that says you can't do that. So I think that, these certain things that we think of as, critical and pushing people towards the corporate form did not necessarily exist in China, but other things did. I mean, as Henry mentioned, I mean, even though you can sue and be sued in court, there's still a great deal of ambiguity over how you go and you get all the different individual partners to pay up. Well, in a corporation, you don't have to do that, but that's because you're not going after the partners at all, right? You're just going after the corporation and its assets. So the creditor is going to lose out on what might have been the additional resources that you could club back from partners, but on the other hand, you don't have, the problem of trying to chase down all those, derelict partners. So it's a very mixed bag, and I do think ultimately what happens is that the international standard becomes what everybody has to adhere to if they're going to do international business.